Okay, I think we're good to go. Ladies and gentlemen, thank you very much for joining us here on this very interesting panel this afternoon. My name is Boue, and I work for BSA, the Software Alliance. For those who don't know, BSA is a global association for the software industry. And our companies are at the forefront of really the digital world as we know it. They provide services to governments, companies, and all the digital economy, digital world, digital society that we live in is underpinned by these companies. Now, one of the key elements of that is the underlying thing is cloud computing. Cloud computing really allows data to be transferred all around the world at any given moment, data to be stored in different locations, not always at the same time, not always at the same place, and really is about all the efficiencies that we've come to know and love. Now, this move to the cloud has also created a lot of unease and tensions with law enforcement, because law enforcement, who have a legitimate purpose in policing our societies and combating serious crime, wants to have access to that data. And they sometimes want access to that data, which is in another location over which they have no jurisdiction. And how do we go from there? How do we move from that? Now, there's a very important system or systems that exist, the mutual legal assistance treaties, that were designed to provide legal certainty in the full respect of the law to ensure that data could be shared with law enforcement. But in this digital age where gazillions of bytes of data are created every second, there's a growing feeling that these systems are too slow, are too cumbersome, and we need to upgrade them. So we've seen governments around the world really asking companies to turn over data for law enforcement purposes. We've seen companies suing their own governments for refusing to actually turn over the data. And we've seen recently legislations coming out to try to solve these issues. So in the spring last year, we saw the US Cloud Act enacted in the United States. A few weeks, months later, the European Commission proposed the e-evidence regulation that is also trying to seek to do two things. Is to ensure that law enforcement can have access to data that it stores in different jurisdictions, in different markets, and also trying to ensure that human rights, fundamental human rights, and privacy are protected. And so this is what we're going to be discussing on the panel this afternoon. And to kick us off, I will turn over to Diego Naranjo from European Digital Rights.
Thank you so much. Good news, I will not be reading bios tonight, so I'm going to save you some minutes for that. You can read them yourself in the website. So we have a very interesting panel. I think the key points were already highlighted, but so I'm going to just briefly introduce the speakers and then kick off with some questions. First, we're going to have Tania Schroeter from she's a Deputy Head of Unit of the Indigenous Justice. We have Peter Kimpian, who is in the Data Protection Unit in the Council of Europe. We have Maximilian Schubert, who is the General Secretary of the Austrian Association of Internet Service Providers, and also President of ISPA, the European Association. And finally, Katitza Rodriguez, who is the International Rights Director for Electronic Frontier Foundation, who is one of the EDRi members. First, Tania, I'd like to start with you. So there's some criticism from the civil society, from the European Data Protection Board, from the German Association of Judges. So I'd like to ask you to convince us. So what is the problem that we're trying to solve, and how is this proposal, the e-evidence proposal, going to solve it?
Thank you, Diego, and hello, everybody. Very happy to be here. Thank you for inviting me to this panel and giving me the opportunity to explain a little bit our proposals, because it's a complex issue that I think deserves to be explained and deserves also a public debate. So Thomas has already told us a little bit about the problems at hand. The starting point of everything is electronic evidence and the specificities of electronic evidence. Why is it so different from other types of evidence and requires specific regulation? Well, the problem with electronic evidence is that it is volatile. It can be moved very quickly. It can be deleted very quickly, and there are actually also obligations for companies to delete this data within certain time frames. And so it is really of essence here to be fast. If you have to investigate a crime and you require this evidence, you have to be quick, because otherwise this data will be gone. The second thing is that there is now an increasing number of criminal investigations where this type of evidence is relevant, and the tendency is further increasing. We have done a little survey and came to the result that more than 85% of criminal investigations nowadays require electronic evidence, and in 2/3 of these cases, you have to do a cross-border request. So that's the next specificity of this area. We are, because of the internet and all the benefits that the internet brings us today, service providers can offer their services from anywhere in the world. They don't need to be physically located at the place where they offer the services. And so when you require, as a law enforcement authority, when you need that data, you will very soon be in a cross-border case because the service provider is a foreign service provider, or because the data that you're looking for is stored on a server somewhere abroad. So you have to use international cooperation tools, which were designed at a time where international cooperation was the exception. You were normally doing your investigation on your territory. You had your witnesses, your offenders, your victims on your territory. And so the judicial cooperation channels that we have, the mutual legal assistance and in European Union, the European Investigation Order, are procedures that are not really apt to catch the very high number of cases where this electronic evidence is nowadays required. So let me just also say a word about what we refer to commonly as the voluntary cooperation. So nowadays, MLA is not actually the predominant way to obtain electronic evidence because in parallel there has been a channel of direct cooperation with service providers, notably with US service provider, which has developed. US service providers can, under US law, share non-content data with foreign authorities directly without requesting MLA requests. So this has actually become nowadays the predominant channel for law enforcement authorities to obtain electronic evidence. To give you a few figures, we are talking, if you look at the United States, where most of the big providers are headquarters, we have a few thousand MLA requests per year coming from Europe. And compared to that, we've had in 2017 124,000 requests to the big 5 US providers. So that is the reality today. So when our proposal was devised, we did not only try to address the shortcomings of mutual legal assistance, which are mostly the speed, the lack of speed. An average request takes about 10 months to the US to be answered. But we were also trying to address the shortcomings of this voluntary cooperation, which is a channel that takes place without any clear legal framework, where service providers actually decide whether they're going to give the data or not, and where there's no legal rights for the persons concerned, neither, that they can invoke. So that's a little bit the issues at hand. Now, the tricky question, and why we are sitting here and debating this, I think in 3 panels at this conference, is the question: how do you ensure the right balance between, on the one hand, the efficiency of the procedure, giving law enforcement and judicial authority a procedure at hand that allows them to obtain this data at all for the investigations, and on the other hand, securing the fundamental rights of the data subjects whose data is concerned here. So we have devised in our evidence proposal a form of direct cooperation with service providers in another member state. So an authority can address a service provider in another member state directly without going through the normal judicial cooperation channels. But you have, of course, to put in place some safeguards in such a system to make sure that fundamental rights are preserved. And there are actually different avenues how you can do that. And the first one that you can do is to regulate the conditions for issuing such a what we call European production order, and we have done that in our proposal. We put conditions in there. We put, for example, the obligation for a judicial authority to be involved when such an order is issued. You can put thresholds in terms of the offenses that are concerned here. We did that as well. You can put in some requirements of proportionality. So that's one possibility. The second one is that you give service providers a certain role. So the service provider who's addressed with such a European production order. That's again a very difficult question. What should be their role? Should they be able to check these orders, check the legality of these orders? Should they be able to refuse and say no, this is not legal? Should they be able to challenge them? There are different views on that. Some also among service providers, actually, some think, no, it's not our role to check legalities of orders. Others think they should be able to do that. So in the Commission proposal, we've given them a right in very obviously abusive cases, give them a right to raise that. As a remedy. In the general approach of that the Council reached in December, this was again deleted. So it's a question we will certainly still debate that with the Parliament, but it's a very interesting question. The third question, possibility you have for ensuring fundamental rights is to give the data subject rights. And there, the starting point is that you have to inform the data subject that his data was requested. And the tricky question is, at what point in time do you inform it? Because if you inform the data subject too early, you might jeopardize the investigation. But you still have to inform it at a stage that he can maybe still use remedies. But the data then at that moment will maybe already have been transferred. Here we tried as well to find a balanced approach in the proposal, saying that the subject had to be informed in all situations, but that this could be postponed if there was a risk to jeopardize the investigation. And then, of course, you have to give the data subject, legal remedies to challenge the legality of the order. So that's something that does not currently exist in many member states at national level. And so we think that with our proposal, by establishing this principle, we're actually also raising the level of safeguards here. And then the fourth possible avenue is actually to involve another member state. So that's, again, a very debated question. Do you, like in mutual legal assistance or mutual recognition procedures, do you involve an authority in another member state and give them the possibility to check or review these orders? And in the Commission proposal, we have decided not to do this, but in the discussions in the Council, we had a lot of debates if another member state should be involved. So the first question that you have to look at here is, which member state at all? Should it be the member state of the service provider, who generally has absolutely no link to the case at hand, except that the service provider or its legal representative will be established on its territory? And then the second possibility is to go to the member state of the person concerned. So that was another possibility that we discussed, but in the end, the Council decided to go for the member state of the legal representative of the service provider, because that will also be the member state that has a role in enforcing these orders, and to give them the possibility to invoke certain grounds for content data only. So it's in the general approach, the involvement of this other member state is limited to content data, and is also limited in terms of cases to those situations where the person, the data subject, is actually not in the issuing state. So that's the compromise that came out of the general approach, and we will certainly still be discussing this again with the Council, with the Parliament, sorry.
And regarding this collaboration between member states, I'm a bit hesitant to how this will work in practice. For example, in the case of the European arrest warrants, sometimes there is not this trust in each other member state, and we see a tendency in some European states to go to the populist right-wing, ultra-right-wing. And so is this going to be working in practice, or can we face the same problems of trust than with the European arrest warrants?
So the question of mutual trust is again a tricky one. We have so first of all, we have harmonized certain rights in Europe. We have harmonized procedural rights. We have harmonized, for example, the rights of a person to have access to the to his file, on the basis of which he will be arrested or convicted. So we have the Charter of Fundamental Rights. So we have, let's say, a minimum understanding of protection in the Union, and I think that for instruments like the European arrest warrant, you also have other things like that are not necessarily linked to the legal system, which are linked to things like detention conditions, which might also play a role. But a particular challenge is the rule of law issue that we're having in certain member states, and you have either the possibility to stop all judicial cooperation with these countries, or to address it with other procedures. And in the Commission, I think we are doing quite a lot. There's a lot of efforts at the moment in procedures and rule of law issues with certain member states, but the judicial cooperation instruments cannot necessarily be stopped altogether just because of these other procedures. So it's not the place to solve them. There are other avenues for that.
Okay, thanks for that. Regarding Commission proceedings, we're still waiting for the ones on data retention. You're welcome to start them whenever you want. But let's move now to Peter Kimpian. So what's the position of the Council of Europe? Now you're working on the second additional protocol to the Budapest Convention, and how do you think that this proposal would improve the situation with the MLAs, and how will they run more efficiently thanks to all of these changes?
Yes, thank you very much. Good afternoon, everybody. I thought that I will use this introductory part of this panel to draw and to show you in a presentation the overall structure and the legal framework where we operate at the Council of Europe. And maybe it will be familiar for some, but I think it's worth mentioning that we are not at all in the same environment that Tania spoke about. So it's not the European Union. We don't have that kind of integration and common policies or enforced cooperation. But to start with the convention which are involved in this discussion, it is to say that the Council of Europe legal instruments are based on Vienna Convention on the law of treaties. So they are basically international public law. We have more than 200 conventions. Some of them are open, so third countries can join. So it's, for instance, the Lanzarote Convention on the Protection of Children, or the Istanbul Convention on violence against women, or the Budapest Convention on cybercrime, or the Data Protection Convention. The two conventions I thought that I will speak a little bit more about. So the Budapest Convention has been open to signature in 2001, and its main objective was to pursue a common criminal policy, basically with the aim to protect the society against cybercrime. And they foresee the adoption of appropriate legislation and to put in place an enforced or a close cooperation and at the international level. So it's the first and still the only binding international treaty on crimes committed via the internet and other computer networks. And it's dealing particularly with infringements of copyright, computer-related fraud, child pornography, and violation of network security. It has currently 62 parties, and 9 other states have already been invited to accede the Budapest Convention, or they already signed to it. Since the beginning, I would say, or not later than its construction, the party has already started to search for solution for the access to electronic evidence by law enforcement in a different jurisdiction. As you might easily understand that in an international relation, it came very quickly into question. So first they created a working group which operated from 2012 and 2014, and after a so-called cloud evidence group tried to find solution 2015, from 2015 to 2017. But it ended with a decision which the committee of the Budapest Convention, the so-called TCY committee, took in June 2017, that to start drafting a protocol that would enable to address this issue and to offer a viable solution for the parties. And they set a time frame from September 2017 till 2019, and expressed their wish to regulate issues such as Tania also mentioned, and Thomas also mentioned, the improvement of the MLA system via, for instance, an expedited MLA for subscriber information, or the international production order, or joint investigation and emergency procedures. They also wish to incorporate into this work the provisions on direct cooperation with service providers in different jurisdictions, and to include other provisions on framework and safeguards for existing practices and for rule of law in data protection issues. And basically, I have one figure, but Tania also mentioned, very similar numbers. The main factual base that I can present to you now, it's on this slide, that it's coming from the transparency reports of big companies. They're saying that there are more than 170,000 requests per year coming from mainly European countries, or countries party to Budapest Convention, and there is a response rate for 64%. So as a data protection expert, my first question was, when I saw this table, what is the legal ground for all this? All right, so let's turn to the other convention, which is the Convention 108. But first, it is important to say that the right to privacy is universal human right, and the Council of Europe has always had this this take on and this approach towards this right. It is in the European Convention on Human Rights, and Article 8 more precisely, and the court several times reiterated, the European Court of Justice, that it is an enabling right, which basically it means that without this right you will not be able to exercise your other rights properly or to the extent it would be desirable. Currently, Convention 108 has 53 parties and some new observers that recently joined to the work of this convention. So we cover also roughly 60, 70 countries all over the world. So you can see the map on the slide. I will not talk about the convention and the modernization process, although it's very interesting topic, but it's not the topic of this panel. It is only to say and to underline that during the modernization process, which ended on 18 May 2019, two objectives have been preserved, which is quite an achievement, namely that the convention, in the modernized version of the convention, will preserve human dignity in the digital age by its application, and still will enable free flow of data between parties, which is one of the sure necessity for data controllers today. Only some provisions about the convention which can be interesting from law enforcement perspective or with relation to the Budapest Convention and more specifically to the second additional protocol. So the Convention on Data Protection of the Council of Europe applies to every individual within the jurisdiction of the parties, regardless of his or her nationality or residence. It has a focus and the concept of a fair balance, and the need to striking a fair balance between all interests concerned is also in Article 5 of the Convention, which is quite relevant when we speak about law enforcement needs and interest and guaranteeing human rights. There is a rather robust provision on the sensitive data and under which the criminal data also falls, and the convention attached to it a necessity for appropriate safeguards. Additional, I would say additional appropriate safeguards, which needs a further effort from the side of the data controller on this. So I would show this slide to say that, and to speak about the exceptions, which is really a state-of-the-art part of the convention, and which really summarized the quintessence of more than 30 years of the jurisprudence of the court, and has general requirements as well as particular requirements when it comes to the lawful use of exceptions. I will sum up with the transborder flow part of the convention, which is highly relevant in an international law enforcement cooperation, which is the aim of the second additional protocol of the Budapest Convention. The main rules are free flow of data between parties and appropriate safeguards when the data goes across the border to one party. Supervisory authority also got reinforced, and currently we have 25 states who signed already the amending protocol to the Budapest Convention. Special Rapporteur of the United Nations on the right to privacy also called upon UN member states to join this convention, as it really sees as a global standard for data protection that can guarantee a high level of protection of individuals, even in law enforcement context.
Thank you so much, Peter. Indeed, the Convention 108 is a global standard on data protection, and we advocate also for as many countries to sign as soon as possible, sign and ratify. And because after the GDPR, with all, even if it's not perfect, of course, we think that could be the way to go for the rest of the world. Maximilian, I'd like to turn to you directly. I'd like to know, well, very simply, what's the vision of Euro-ISPA in this regard? Which are the problems that you see regarding safeguards for businesses, individuals, and when implementing this e-evidence proposal in practice?
Thank you, Diego. First of all, thanks a lot for the invitation, also on behalf of Euro-ISPA. I think we all agreed that the system needs some improvement. We only disagree how we're going to reach that goal. But before we're just going to dig into the topic, I would like to stress the good cooperation we have had so far with the European Commission. I think we had a very fruitful exchange of ideas. We randomly fully agreed, but we see a few aspects in the proposal we really support, and we are grateful for taking them on board. And also Council of Europe. I think we, working in Brussels, we're living in the Brussels bubble, but also in a kind of European bubble. But as soon as you move over to Strasbourg, you're in a totally different international sphere, together with new ideas and new challenges. And that's something really important if you want to have a good debate about the topic. Euro-ISPA was one of the institutions first to criticize the proposal when it was published by the Commission. And I already told you there are many positive aspects we see in it. But when we look at the e-evidence proposal, it's clear to us it's going to be a blueprint for many more kinds of data being exchanged. So we are convinced that if we're now going to find a system, if we're going to construe a system, we make it proper, because it will serve for future similar systems. That's the reason why we're very reluctant at some points, but always open to discussion, to discuss the topic. And also when discussing it with the Council during the last half year, I think we've been quite successful. For example, to stop the Council from including real-time interception, which would have been, in our opinion, a real problem. Let's be open and honest about it. And then we were happy to see that an exemption for small and medium-sized corporations was included, and that the topic of the safe transfer of data and the topic of authentication got included into the proposal. Maybe just 2 sentences about EURISPA. We are an association of internet service providers. We've been around for more than 20 years. That's relatively old in the internet sphere, I would like to say. And what probably sets us apart from many of our colleague associations is that, first of all, we are very big with more than 2,500 corporations. And out of these 2,500 corporations, I would say 85% are pretty much invisible in the internet ecosystem. You usually don't get in touch with them. But these are the corporations you need for the internet ecosystem to function. So when speaking about regulation, you must not only have the big ones in view, although they might be the dominating one in figures, but you have to be in mind the whole internet ecosystem. So if we now move on, I think the challenge, what we're all speaking about, is pretty obvious. Law enforcement is requesting data and expecting us to send data back. If we look at it on the global scheme, when being asked to transfer data to a third country, yes, it is indeed quite a complex process which takes time. But you might have seen on the, one of the slides from my colleague from the Council of Europe, there were member states which had a success rate of 91% in getting their request answered, and there was even one having a 1-digit response rate. So I don't want to dig into it, I just leave it open to discussion if there's maybe room for improvement on the side of individual countries to improve the MLAT system. But once again, yes, we all agree something needs to be done. If we look at the European scene, it's already much easier. Traditional authorities can already contact each other, so that's kind of an improvement. However, now when we're looking at the e-evidence proposal, we suddenly see that one of the actors got cut out. The receiving state judicial authority, which used to be the one making it, taking the decision whether the measure is proportionate and legal, is now no longer being involved. They might be involved in respect to content data being requested, but then they're only being notified. So the question is, if we want to remain at a high level of civil rights protection, is it then the ISPs who are expected to take over this public function to guarantee the rule of law? And you might say, well, you're corporations, you're just receiving orders, and you will act them out according to the law. That's true, that's what we do. But please keep in mind that if one of our members is appearing in the newspapers to have handed over data sets in quantity much more than necessary, and probably also not on the best legal grounds, it will be our member being in the newspaper. It will be this company losing customers, losing trust. And then it helps not much if you can say, well, but I had a legal ground, I had to do it. So please keep this in mind when we're discussing the topic. So what are the challenges we see? We see a lack of integrated safeguards and legal uncertainty, and this legal uncertainty in the worst case actually making the system slower than it is now. What we see is, Tania was in her introduction mentioned the threshold of a 3-year sentence. But the question is, who is stopping a country from turning a petty crime or a crime related to religious, etc. beliefs into a crime being sentenced with more than 3 years in punishment? Secondly, what about dual criminality? Taking the example of European countries which have particular laws, so an Austrian ISP might be obliged to hand over data to, let's say, Polish authorities because they're investigating a crime for something which wouldn't be a crime in the first place in Austria. You might not say, well, you know, that's an artificial argument, that's more like a scientific theory. No, this happens in reality. If you talk to people who are working in this field, they say dual criminality is a big issue. And I personally think if we want to solve the issue of e-evidence, that's one of the problems we really have to tackle. Secondly, the single points of contact. I reminded you previously that the success rates of particular countries are different in respect to requesting data from ISPs. One of the reasons is that in some countries we see that there are specialized units within the Ministry of Justice or Internal Affairs which do nothing else than just receiving requests from courts and forwarding them to the corporations. So you've got people who are specialized in doing this and who might spot, for example, that there's a case number missing, that there's a signature missing, or that the claim altogether won't qualify to receive information back. So I think that's an easy measure states could do to speed up the whole procedure. And one big topic which is very much at the core of interests of internet service providers in Europe is the topic of the authentication and the integrity of the order certificates we are receiving. Now imagine, let's say, an average SME ISP. They will have about 5 people working there, and imagine them living in Sweden, and they're receiving an order from an South Italian port authority. And they might assemble around the table, might stare at the document, and might say, well, you know, the stamp looks funny, reminds me of a mineral water bottle, but that's all I can say about the authenticity of the request. So this kind of, is quite a big challenge for our corporations. So to give you an overly simplified example, especially through the GDPR, ISPs have been quite, or have to be quite vigilant about the data they're holding of their subscribers. And we are now very reluctant to hand them over using a system which we don't think qualifies as safe in our eyes. For example, if you're working for a big corporation, an international one, and you're receiving a request from the police asking them to send you subscriber data using email, you can just reply, no, there's no way doing this because we couldn't violate our own guidelines which are forbidding us such a transfer. So this is why we are very reluctant opting for a system which might actually decrease the level of protection we can offer to our customers. And now speaking about the way data is being transferred, we are being told, well, you know, there's the e-codex system, and just be positive and trust us, and you know, it will be in place by the time it all enters into force. And by the way, in case it doesn't, don't worry, because we can still rely on fax machines. And as you can see in the background, fax machines, yes, they work in many cases, but very often they just don't work and they don't fulfill the quality standards we're having in this millennium. Fax machines is something from the last millennium, and we don't want to see it in the online, working in the online world in these days. Just imagine something is unclear, you would like to call the person back and ask, you know, what they really want, and you can't even read the phone number printed on. These things happen. That's not something we are making up. Good. And to end, our further concerns, well, first of all, transparency. It was mentioned there are 3 presentations about this topic, and also referring to the Cloud Act. When we look to the Cloud Act, however, there's a lot of criticism, but one aspect is very positive, I would say, about the Cloud Act. In the Cloud Act, transparency is the rule, not the exception. And in respect to enforcing states, I've mentioned that previously, I think not only should they be involved for content data, but for other kinds of data, and referring to the time frame. Just again, think of our entity with 3 people working there. If it's an urgent request, they have to respond within 6 hours. And to be able to offer a 24/7 service, you need a minimum of 6 people working there. So my question is, how are we expecting a small and medium-sized enterprise to comply with the 6-hour time frame? We think is honestly difficult. Draconian sanctions, of course, also to be mentioned. I think they were just copy-pasted from the GDPR, but also not the best idea in this respect. And it also burns down to, once again, an SME exemption, which we need for the reasons I've just given, and cost reimbursement, especially if we are expected to have 24-hour service, 24/7 service. This is something which would seriously impact competition in this field, and to mediate this, all companies should be entitled to receive cost reimbursement. Thank you.
Thank you, Maximilian. I'd like to leave around 30 minutes for the public to provide questions. We still have one more speaker to go, but please, if you're in the audience, warm up, prepare your questions and be ready to jump. But now, Katitza Rodriguez from EFF Well, the MSA say that MLAs are too slow. That is the system broken, and how do you see, comparing with the situation in the US with the Cloud Act, how this will affect the privacy rights of individuals in the EU as well? So a bit of both.
Thank you for your question. First, I think that since we are talking about different regimes here, the e-evidence, the discussion of the second additional protocol to the Budapest Convention, and also the Cloud Act, we need to think that not all the countries will enter into this direct cooperation necessarily. And MLATs is true, it's a problem for many of them. There are many requests. The grand majority of data is handled by companies based in the United States, so I could understand being a bottleneck of number of requests. But there are, and I think we should still thinking on how to improve them. And that's one of the things that, for instance, the Council of Europe is doing on the second additional protocol on creating, for instance, emergency MLATs and how this emergency will be defined and how you can access them within the context of the MLATs. Academics have also written a lot and also access now how to improve MLATs. Not only funding, but probably have a specialized courts who are only dealing with cross-border access requests. So one of the problems is competitions. For instance, a lot of requests, and you have domestic cases versus international cases, where the police is not so involved in those cases, so they don't give priority. But if you have a specialized courts, people with staffers who are just answering international requests, that speed can improve. We also should recognize that according to one of the budget reports from the DOJ, the number of requests has speed up a little bit compared to a couple of years or a few years ago, and that's something to take into account. Now, there is a lot of discussion about creating these alternative mechanisms, and the Cloud Act, we will talk later, having already adopted as a law in the United States. And I think in any mechanism of direct cooperation that are being discussed also in the Cloud Act is only for content of communication. In e-evidence is for content, metadata, or access data and transactional data, I think, and content. And in the Budapest Convention, the second additional protocol, as far as I understood, is focused only on subscriber data. Those old mechanisms are trying to get rid of traditional safeguards that we have in cross-border cooperation, like judicial-to-judicial cooperation, or dual criminality. In cases, for instance, when in certain cases, for instance, that may impact certain rights. So, for instance, cases that are related to free speech, that in a country is a problem, in another country it's a crime, in others it's not. It gets complicated when you get rid of these legal safeguards, and it has implications. We're talking about criminal law, and it has serious implications for people. But for no reasons, I think that people are talking, this process is slow, we have to get alternative. But those alternatives, it seems all is not about funding, it's not about speeding up. For them, is what I hear is that it's the safeguards who are making them slow. As getting off the judicial cooperation, is getting off the dual criminality, is getting rid of, the gold standard in the United States, which is probable cause. And not adopting other safeguards or good safeguards or gold standards like the GDPR. And so, I've seen that if the United States or other countries decide to go ahead with this, and it's already a law in the US, we lost that battle there, we need to ensure that the safeguards are high. But when we have these discussions actually in the table with companies or even with prosecutors or policymakers in different parts of the world, when we talk, we all say high standards, but when we're actually discussing the nuance of the standards, they are not high standards necessarily. Notification provision, it's not like that. They talk about blocking provisions when there are legal safeguards, and so the word high, I don't know what it means, and this gets complicated when we get and analyze the gap that exists between national laws and the courts. So if we go ahead and analyze, for instance, and I jump a little bit on that, but for instance, if we start analyzing the decisions of the court, the Teletubi case, for instance, the ECHR, they are good safeguards, and when you analyze the domestic law of certain countries, they are not matching that legal safeguard that the court have adopted. And so there are really problems about harmonization of legal safeguards. And when you're trying to harmonize legal safeguards, they're trying to go to a lower denominator instead of a high denominator. And that is a concern, that the safeguards that they are seeing is high, is not really high, compared to someone like me who does comparative analysis of different laws. I try to see different kind of provisions that will protect privacy. And so, for instance, if we are talking about subscriber data, we could go and see, for instance, the Constitution of Canada and the court decision in Canada that require a judicial authority to access subscriber data. And also PIPEDA, which is a data protection law in Canada, also forbidden to voluntarily hand over subscriber data. And if we review the Constitution of Slovenia and the decision of Benedict versus Slovenia, also in the Canada is in the context of anonymity, So that's very important because not all subscribers. And in the context of Benedict, it's also about protecting accessing the subscriber data with legal safeguards. But if you review some of the EIO or the second additional protocol, well, they create this different tier of level of protection of privacy where subscriber data have less protection than other safeguards. And if you review the US law on metadata and on subscriber, they have very little protections to compare to other legal regimes. So it's a lot of disparity, which gets really complicated when you're trying to enter into a bilateral agreement.
Okay, I can see more complications now than before. Are there any questions from the public already? If you have any questions, please stand up. You can go to one of the mics. Yes, please go ahead. Yes.
I have a question, and for anybody that wants to answer it on the panel. I'm Joris van Hoboken. The question is basically, I mean, my sense and intuition about many of the proposals and initiatives to address cross-border evidence seeking is that a lot of the current practices are also kind of going under exceptions and emergency procedures because of the legal system not having enough flexibility. And I mean, there are in the law also these types of exceptions. They are there, so it is not like entirely extra legal. But I had the sense that a lot of these proposals are trying to pull more of the cross-border e-evidence within like stipulated legal procedures. Is that correct? And what is your assessment of how successful the different proposals are going to be to create that new situation?
Okay, we take another question.
Hello, Tobias Moschitz from Dutch Schutzraum, Germany. My question is, we had a lot of abuses of international cooperation in the last time, or attempted abuse. And the question, shouldn't we rise the standards and the safeguards instead of lowering the safeguards? Because at the moment, during the development in the world, even in Europe, there is a need for more instead of less protection.
Okay, the last question, then we give the floor to the panelists.
Hello, I'm Ian Fish from BCS, the Chartered Institute for IT in UK. My question is about the different jurisdictions' need for preservation of electronic evidence, whether that's an extra complexity because it probably differs jurisdiction to jurisdiction, and in any case it tends to be very high. So is there any provision in these sort of proposals to actually look at that? Thank you.
Yes, Peter?
Maybe I can give a very quick reaction to the preservation of evidence related question. So yes, it has been discussed at the Council of Europe and at the Cybercrime Committee. And I don't know, and I don't have any specific information that I can share here, that it will be included in the protocol, because nobody knows. It's a draft and there are several ideas. But I can say that the overall feeling about the preservation of evidence is that it's a less privacy intrusive measure. However, there are several practical implications that has privacy and data protection consequences. Therefore, we have to study it more closely. But yes, I would answer then yes, it is on the table.
Yeah.
Okay, so starting with the preservation, last question, there's also provisions in the e-evidence proposal on a European preservation order. So the logic is the same as for the production order. You can directly cross-border ask a service provider to preserve data, and you would do that, for example, in situations where you cannot issue a European production order because you are below the thresholds and you need to go the European investigation order path or MLA path to obtain that data, and then you can ensure that the data is still there. The problem with, I mean, we've heard also people wondering why preservation alone would not be enough. You know, do we still need to also regulate the production of the data? Wouldn't it be sufficient to say preservation in a quick way, and then you can go via MLA to obtain the data? But the problem with that is that in an investigation, in a criminal investigation, normally you have chains of evidence, and you start by needing to find out who's behind a certain IP address, who has done a certain communication, so to find out the subscriber. Then you might need in a second step to find out with whom this person communicated, and then you will come to the content. So if there are several steps and it takes you already 10 months for the first step, you can imagine that will not help the investigation forward. So preservation is certainly an important tool. And by the way, in the Council of Europe, there are already in the Budapest Convention very efficient and working provisions with a 24/7 network on preservation. So I think that works quite well. But preservation alone is not the solution. On the cases of abuses, I don't know exactly what cases you were referring to, but the question of the safeguards is, I think, independent of these abuse cases. You need to have safeguards in place to prevent these abuses and for the majority of cases. And so the trick question is, what are the appropriate safeguards? And when you look at the voluntary cooperation, which is the predominant way, let me repeat that there are hardly any safeguards in place at the moment. So it's really key that you put in some safeguards. And compared to the national to domestic cases, when you're going cross-border, it is also clear that you need higher safeguards than in purely domestic cases. So that's understood. And then finally about the emergency question, I'm not sure I understood it correctly, but the idea is, in practice, if you have a real emergency case, if you have a threat for life or a limb of somebody, if you have a terrorist case, that's areas where international cooperation actually works pretty smoothly, where even under judicial cooperation you can get information within very, very short deadlines. So that's areas which are where you know there is not necessarily a need to provide for other solution. What you need is actually a solution for the big bulk of maybe a little bit less urgent cases. But as I said, the urgency for e-evidence derives from the fact that the data will be gone if you don't obtain it quickly. So not emergency in the sense of you need to act quickly, otherwise somebody will die. There actually it works, but it's really for the big bulk of the other cases where if you don't get the data, you will just not be able to carry out your investigation successfully.
I think Katitza wanted to perhaps reply to one question. I also mentioned the issue of the Cloud Act that you mentioned before briefly.
Oh yeah. What was the question? Emergency. Yes, there is discussions on the second additional protocol to the Budapest Convention on emergency, at least on what have been discussed in the Octopus meeting, which was public, and we attended. We have a critic to the process on the second additional protocol because it's closed doors. Civil society cannot attend the meeting. We only have consultations, and we see like a consultation when they ask you. Very vague opinions, everyone giving opinions that are all over the place, and it's not really a substantive discussion of the substance of the treaty in detail. And the actual negotiations and the actual discussion of the text are closed doors. There are certain papers that get released, but the most interesting ones on this direct cooperation are not. Now, when you discuss, there are many working groups on this topic now because it's becoming like an important topic. Much of the discussion are related to actually sometimes there is problems in the definition of emergency situations. Some countries, like the United States, have a good standard, I will say, on emergency because it's very narrow, but there are other countries who have even broader. For instance, there is exigent circumstances, which is more than just death of life in Canada, you know, and then they try to reconcile that. From EFF perspective, we are worried about going far beyond what is the traditional concept of emergency, which is narrow to death of life of a person. We are worried that this gets extended, for instance, in case of loss of evidence. As people have discussed, there is no need for that because there are preservation orders. But as I said, they forget that they propose to get rid of the Mutual Legal Assistance Treaty. That's their proposal in order to expedite. And this means also renegotiate all these other things that are really problematic if they end up, for instance, in the Council of Europe defining emergency in a more broader term. I don't know. There is a consultation right now on the topic in the website of the Council of Europe. So if you want to ensure that this doesn't get so broad, probably you should participate. That will say, I wouldn't say if our positions will be considered because it's closed door, but at least we can make our comments. Regarding the Cloud Act, yes, I was waiting for your question. Thank you. Yeah, it's very important to have a definition of the Cloud Act. There are two parts, and people get confused of those, and I want to make sure people don't get confused of those. There is two parts. The first part is the extraterritorial warrant provisions of the Cloud Act. Most people talk about the executive agreements, and that's the second part. Right now, I'm talking about the first part, just so you know. So in this part of the Cloud Act, the United States will have extraterritorial authority to access the content of any person in the world whose data is stored in the European Union or any part of the world. In other words, the US police could compel a service provider like Google, Facebook, or Microsoft to hand over data stored in Europe. It could also apply to foreign companies as long as US court finds a sufficient jurisdictional nexus to send an order. So Telegram, even though in German, if they have sufficient jurisdictional nexus, could be subject to an order because it serves customers in the United States. Now, in this part of the Cloud Act, we have to be clear that the use is saying that they will be able to have this access regardless of any agreement. And this, I agree, is what previous speaker is saying is not new powers, but it was challenged. There are companies that sometimes do a good job, and they will challenge this decision in the United States, and many civil society like EFF joined in amicus in support of this company, Microsoft, but sadly the Cloud Act was approved and the final decision was the court was declared moot. 1 minute, okay. Just want to say that this may create potential conflicts with Article 48 or 49 of the GDPR, and there might be this needs to have legal analysis in that regards. And also we should think that which will be the legal standard for accessing the data by the United States, because usually the Fourth Amendment have not protect the right of foreigners as they protect nationals. So maybe the accessing the data with a lower standard, that's our belief in EFF. And so this will create these two levels of protections between the protection of privacy for Americans and the protection of foreign data stored abroad. I'm not going to talk about the second part because he already raised the hands for 1 minute. So,
okay, thank you for that, Max.
Thank you, Diego. Maybe just a short remark in respect to abuse. I think we're very fortunate to have personnel in law enforcement who is passionate about their job. But being passionate and really wanting to solve the case at the same time, unfortunately, also means that they will try everything they can try to get their case solved. And I would say it's not the big proportion of people really trying to abuse it to stalk their ex-girlfriend. It's more like they're seeing themselves in a dead end in the investigation. Then someone says, well, we could try the emergency procedure and we could try to reframe it that there's immediate danger to blah, blah, blah. So these are, how to say, cases we do see, and what we see as when drafting regulation, you have to be very careful not to create the temptation to stretch the system, because we're all humans and we're always trying to test our limits. In connection with that, maybe a different aspect. The Commission in its impact assessment themselves mentioned that cost reimbursement can also have a very good limiting factor. If every request you're making is connected to a little sum you have to pay on, a little paper trail you have to fill in, you have to justify for requesting information. And even if the amount you're paying is marginal, it still means at the end of the day, someone will be presented a bill and someone will have to justify why they did it. And to provide you with a practical example, in Austria, when police was asking for telecom surveillance, they were asking for one of the busiest parts of Austrian's motorway to have a surveillance for 48 hours. And then the telco kind of called back and say, well, we're just going to give you a rough calculation, but that's a 2-digit million sum you will going to have to invest to get this data. We're happy to do it, but still we're informing you. And then it turned out, they said, well, actually one motorway exit will be enough. And I think we can cut it down to a couple of hours. So cost reimbursement has got two sides, and I think both of them are very positive.
Question from the audience?
Yes, a question, maybe also a little bit of a clarification. I'm Patrick Pennings. I'm the head of the Information Society Department in the Council of Europe, a colleague of Peter. I just wanted to say a few words about the consultation process. First of all, you have to see that we're an intergovernmental institution, and the parties to the Budapest Convention are actually 63. They have their own procedures in how an international convention can be elaborated. That is quite clear. And they also have their own mechanisms of consultation. Quite a number of member states do have a consultation mechanism nationally. Some are quite elaborated. So they also insist that these parties to the convention insist that a number of negotiations already take place before they can come to a common agreement at international level. So that basically also impedes in certain ways consultation processes that may take place. We, at the level of the Council of Europe, try our utmost to include as many stakeholders as possible in different consultation procedures, some of them open consultations, as you referred to yourself, on the internet. So with direct consultations which are possible. And I think it's always a bit weird, because when you're in the cybercrime environment and you primarily speak to people from law enforcement, they will have a particular view of how things need to be resolved. When you speak to people from the data protection community, they also have their particular views. And including in my department, it is sometimes difficult to reconcile both positions and make these two communities speak to each other. And I think there is a number of legitimate interests from both sides that we have to be able to reconcile. And that is the process of elaborating an additional protocol or a new convention as we do. Thank you.
Perhaps, Katitza, you want to reply quickly, and I'd like to ask a question to Max.
Thank you kindly for the answer. Yeah, I think that it's really sad that that's the own mechanisms of the cybercrime TCY committee, especially taking into account the open culture that the convention and that the Council of Europe have for writing other kind of documents outside of the law enforcement community. You can be an observer as an expert. Still, you are not the state. You will not be able to take decisions, but you as an expert can provide comments. And in this topic, it's really complicated if you're outside of the table, because you need to understand the legal regimes of different countries and provide comments based on exactly what is being discussed in the table. So it's super hard to be able to do a minimal substantive consultation from the outside. I like the Council of Europe a lot because it's a human rights institution, international, and having so open for civil society in all the other committees. It's just sad that that kind of mechanisms to be able to provide advice as an expert opinion within the law enforcement community is not possible. And I think this is a very complicated topic that requires a lot of understanding of different countries' laws. And that nuance, you miss it by not being in the table.
Okay, a quick question to Maximilian. I'd like to know if you can provide us any specific example of a good practice that any of your members have done. So okay, this is the model that we should be following. If that exists, I don't know if that is the case. And then to Tania, I'd like to ask you as well, how this proposal is going to be interacting with the terrorist content regulation proposal, and how this will also interact with the Council of Europe work on the second additional protocol to the Budapest Convention. How all of these proposals are going to be affecting platforms? Is there going to be one-way solution or one authority that's going to deal with this? Or are we going to be dealing with different systems, different regiments? So first to Maximilian.
Thank you. I assume you're referring to the transfer of data between ISPs and authorities. And I think there are a few good models out there. We have got providers in member states who have established a well-working system who enables them to exchange information with law enforcement authority. But I think also on a national level, general approaches can be made. And in Austria, for example, we have a system that was built in 2012 when we implemented the data retention obligations, and it was done by the University of Vienna together with the Fundamental Rights Institute and all the ministries involved. And it's kind of a mailbox exchange system between the ISP and the law enforcement authority, but it's a public-private key infrastructure. So only the ISP for whom the order is can decrypt it, and only the issuing authority can later decrypt the answer. And in between, we have something like a counter, so you can count the number of files going back and forward. And this system, I would say, is one of the many upsides. It's all you need to run it on the ISP, but also on the law enforcement side is a web browser, so it works quite well while providing a high level in security. And it came along with some standardization. The number of the request forms you can send to an ISP are pre-configured, so there's not much you can add. And the result of which was that the whole process really speeded up. So standardization is a good thing. That's one of the reasons we are very much supporting what the Commission has suggested in the e-evidence proposal in this respect.
Okay, question about terrorist content online. So terrorist content online, the Commission proposal came out after the evidence proposal and was inspired in many aspects, I think, from the e-evidence proposals. There's, for example, the figure of the legal representative, which is also in there. Several provisions are similar, but it is a different purpose. Huh? The terrorist content online is about ensuring efficient mechanism so that terrorist content online can be removed quickly so that it will not incite terrorists further. But there are some provisions, let's say, that make where there can be a bridge where the two proposals could actually complement each other, notably in the terrorist content online proposal. There are provisions that once this content is removed, service providers have an obligation to keep it so that it can be used as evidence by law enforcement. And then you can imagine that, for example, the e-evidence proposal could then be used to request that evidence from the provider. So I think they can work together. But in general, I would also like to say a word that, in particular with the Council of Europe additional protocol to the Budapest Convention, and with the Cloud Act and any possible international agreement, these are all different instruments that in the end need to work together well, and that don't need to contradict each other, and it needs to ideally also they need to have some similar approaches or similar safeguards also. So I mean, these processes are all going not necessarily at the same speed, but we hope that we can ensure some consistency between them.
Now I'm following closely as well the terrorist content regulation. I think that could be a great idea. The Parliament now that is in charge of both proposals right now after the Council achieved the general approach, that they both agree on the safeguard, and they level up the safeguards on both proposals, and they are the same. So the platform, the individuals are not fighting between different proposals. So thanks for that. I think that's a good one. Peter, I'd like to ask a question before I hand over back to Thomas. There's some intention from certain states, not only within the European Union, but in the Council of Europe member states, like for example Russia, and outside we have also some other member states like China that would like to get more access to data. How is your proposal going not to lead to some of these states abusing their position, especially in the case of the Council of Europe member states? So they're going to have this, let's say, easier access to data. We know, let's say, we expect Germany or France or another European member state not to be abusive, but in some extreme cases, are we going to be able to prevent that within the Council of Europe member states?
Yeah, well, I think that yes, and this is why I spoke about the two conventions, because we see that this is the two faces of the same coin. So we have an issue, and from law enforcement side, and to speed up and ease up the cooperation, that will be the Budapest Convention. But for the protection of the individuals, it will be the Convention 108 plus, the Modernized Convention. And for the Convention 108 plus, we did already the exercise that Tania referred to, that is ahead of us for the Budapest Convention to make sure that it is complementary, and it is convergent to other existing and forthcoming legal instruments that are binding our member states, which are, all of them are European Union, are members of the European Union as well. So all of the European Union member states are members to the Council of Europe. So it has an utmost importance. So we believe that keeping that balanced approach and having the acquis, what we have in-house, will guarantee to prevent abuse. One question maybe for the end that I wanted to bring also into this discussion, and maybe to end up with this. The question would be how to ensure the best and the faster that the party to convention to the Budapest Convention accede to Convention 108, and the party to Convention 108 accede to Budapest Convention. So that's the challenge for us more than creating other instruments.
Thank you for that. Very good reply. Thomas, would you like to wrap up?
Thank you very much, and thank you, panelists, for a very interesting discussion this afternoon. I think there's a few things that I take from my panel. I think one of the first things is that no one here questions the need for governments to protect citizens in two different ways. One, in the insurance that serious crimes and proper criminality is pursued, and the law enforcement has the tools to actually do that. At the same time, ensuring that citizens who could be caught in there also have their human rights and the privacy rights protected. And I think from the company's perspective, and I think to Max's point earlier, that's exactly the same. The companies also want to ensure that the customers, be they individuals, companies, governments, can trust them and have trust in the system, can use them, and can also, rely on these things. But also, most importantly, I think Max mentioned it very, very briefly, but this is a very important point. It's to avoid to put companies in conflicts of law. When you operate across multiple jurisdictions within Europe, but also within Europe and beyond, you can be caught between conflicting requirements. So I think one of the things that I find very interesting is there's 4 panels this session on CPDP on this issue. I think we're seeing a lot of movement around the world, be it from the Cloud Act, be it from the e-evidence proposal, be it from the Council of Europe, be it from an MLAT reform. And I think, ultimately, I think this will all lead to convergence to ensure that we achieve different public policy objectives, protecting privacy and ensuring that law enforcement have the tools to do their job. And I think, this is the beginning of a conversation, and I hope, and Katitza, to your point, I think ensuring that every stakeholder, every participant can be part of the debate and explain. And I think these are things that we need to continue doing moving forward. Thank you all very much, and please thank our great panelists from this afternoon.